We'll grab everyone out of the hallway. If everyone wants to come in and take a seat, please. We want to stay on schedule. Thank you. I just wanted to mention that the Center for Inquiry DC is having our 5th anniversary on November 12th. I hope you'll all come out and support us. We will have blogger extraordinaire, Greta Christina, Jennifer Michael Hecht, and our CEO and president, Ronald Lindsay. It's going to be a lot of fun. We have door prizes, volunteer recognition, lots of fun things going on. So I hope you will all come out and support us. Thank you.
Well, it's my pleasure to introduce this morning's very distinguished panel, very briefly, and then we'll get right into it. I understand the speaking order is more or less going to follow the order in the thing. So Ron, you're going first, and then Barbara, and then Barry. Okay, I'll introduce folks in that order. The first speaker on this panel is Ronald A. Lindsay. He's president and CEO of the Center for Inquiry. He received his Ph.D. in philosophy from Georgetown, here locally, and also his J.D. from the University of Virginia School of Law. He has been described both as a lawyer masquerading as a philosopher and as a philosopher pretending to be a lawyer. I don't know who's describing him that way, but yeah, it fits. Both statements may be true. I think you might have written this. Okay, so one undisputed fact. He is the author of, a terrific book called Future Bioethics, Overcoming Taboos, Myths, and Dogmas. Please help me welcome Ronald Lindsay. Next speaker. And then I'll surrender the podium. I'll get all the introductions out of the way and sit myself down, and they'll give their talks and field their questions. The next speaker is Barbara Forrest. She is co-author with Paul Gross of a very important book, Creationism's Trojan Horse, The Wedge of Intelligent Design. She was an expert witness in the famous Dover School District case up in Pennsylvania, which went our way. Yes, very good work there. She is a member of the Board of Directors of the National Center for Science Education and the National Advisory Council of Americans United for Separation of Church and State. She's a professor of philosophy in the Department of History and Political Science at Southeastern Louisiana University. Please help me welcome Barbara Forrest to our panel. Last but certainly not least, Barry Lynn is with us, who's just a tremendous. Please take notice of the handout out on the table. He has a special event coming up. Barry Lynn is Executive Director of the Americans United for Separation of Church and State, based here in Washington, D.C., dedicated to the preservation of the Constitution's religious liberty provisions. In addition to his work as a longtime activist and lawyer in the civil liberties field, Lynn is an ordained minister in the United Church of Christ. He also serves as a host of a radio show, Culture Shocks. Please check it out. Write that down, Culture Shocks. It's a tremendous show, a daily look at various issues affecting society and culture. Please welcome Barry Lynn. As I said, I now turn it over to Ron Lindsay. I believe you'll each do would you like to take questions after each of yours, or would you like to go back into panel mode and field questions generally? It's entirely up to the panel. Okay, great. So I'll let you folks run through in order, and then you can field your questions. Thank you very much, folks. Here's Ronald Lindsay.
Thanks so much, John. Well, as you can tell by the color of my title slide, I'm going to continue with John's theme of trying to scare you, since it's got Halloween colors. One thing, actually, I'll start off by acknowledging that there's a little bit of disagreement between me and John. John actually had a great talk, and he indicated quite rightly that the religious, especially the religious right, is broadening their attack, and they're trying a number of different tactics, but they haven't abandoned, I think, their anti-science tactics. They're just supplementing it. They're trying a variety of different things, and we continue to have battles about creationism and intelligent design as opposed to the teaching of evolution. And that's, of course, what I'll be talking about today. Now, I'm going to be focusing principally on how these disputes have been adjudicated by the courts. But I want you to keep in mind throughout that the legal disputes are really a reflection of the social and political disputes. And at the end of the day, that's what we have to be concerned about. Judges and justices, they're not the offspring of some otherworldly Platonic jurisprudential realm. Some of them may think so, but there's people like anyone else, and they're influenced by the social and political temper of their times. And how they're going to define and understand and interpret key concepts such as science is going to be a reflection of the social and political temper of their times. Furthermore, as John alluded to in his talk, judges just can't decide what they want. Cases and controversies are brought to them, and those cases and controversies reflect, typically, at least in the areas we're talking about, laws that have been passed by state legislatures on a variety of different topics. Of course, I'll be talking about the evolution issue. And the shape of the case or controversy that's presented to the court, again, is going to reflect the social and political temper of the times. I mean, I'm sure many of you are aware of the somewhat disheartening statistic that shows over 40%, some polls say close to 50%, of the American people reject evolution, at least as is applied to human beings. That's pretty, as I said, pretty discouraging. But if it were a higher percentage, if we're 80%, we wouldn't be litigating cases about, oh, should we have a disclaimer on textbooks or not? We'd be litigating the issue of outright bans on the teaching of evolution, which, of course, was the case in the 1920s. I hope we never have a return to that dismal past, but whether we will or not is really going to depend on what people believe about science. Because if, for all practical purposes, people think that creation science is not just a ridiculous contradiction in terms, if they think there's something like that, then the courts are likely to go along with that definition. So there is an important legal battle, and it's important to be aware of the way that the dispute is framed, certainly for those who are advocating this area, but we should never lose sight of the underlying social and political struggle. Certainly, those who are opposed to evolution have never done so. And I'll give this much credit for the fundamentalists and the religious right. They have never swayed from their primary goal, which I think is to foster religious, usually Bible-based beliefs of school children, either directly by teaching creationism or indirectly by teaching or interfering with the teaching of evolution. This has been their goal from the 1920s forward. They've changed some of their tactics, which I'll talk about in a moment, but they've persisted in this goal, and it's to their credit they haven't kept or haven't allowed their eyes to be distracted from this prize. This is what they want, and they will continue to pursue it. Well, you may think from the fundamentalist position that, well, religion, is that incompatible with, religious belief, is that incompatible with evolution? Sometimes the dispute is framed in this way, and sometimes the creationists themselves want it framed this way. But this is actually the wrong question to ask. It's wrong for a couple reasons. First of all, that's a much too general way to phrase it, because you can't talk about something like religious belief. What does that mean? Obviously, there are so many different types of religious beliefs, you just can't say in global terms, well, evolution, that's incompatible with a religion. Because the fact of the matter is, and this actually goes back to the time of the Scopes trial, as we'll see in a moment, many religious traditions accept evolution. So it's an improper way to phrase this. Also, it's just approaching the issue from the wrong perspective. When we're talking about what should be taught in the public schools, we shouldn't, at least at the beginning, be concerned about, well, is this going to affect religious beliefs one way or the other? We're talking about a science course. The question is what we're teaching supported by science? That's the issue. If it's supported by science, it should be taught. If it's not supported by science, it shouldn't be taught. So the idea that somehow we have to figure out, well, how it meshes with religious beliefs is just the wrong way to frame the issue. And as I indicated, even in the 1920s, as I'm sure you're all aware, the Scopes trial attracted a lot of public attention. There were briefs filed, dozens of briefs filed on each side of the case, and there were actually many briefs filed by Protestant, Catholic, and Jewish groups arguing that the Tennessee law should be struck down. And the court pointed out that, Protestants, Catholics, and Jews are divided among themselves about their beliefs of evolution. Now, the court, as we'll see, drew the wrong conclusion from this. The conclusion the court ultimately drew was, well, there's no establishment of religion here because, if we say that we can't teach evolution, that may support some religious beliefs, but it doesn't support all religious beliefs, therefore there's no establishment of religion. Obviously the wrong way to frame the issue, but it did recognize the diversity of opinion. Well, let's talk about the Scopes case for a moment, because this is the first strategy that was adopted by those opposed to evolution, which is a very simple and direct strategy: just ban it. You can't teach evolution, right? Interestingly, though, although laws were introduced in maybe 12 states during the 1920s and early 1930s in an attempt to outright ban evolution, actually 3 states wound up adopting laws banning evolution, all located in the Bible Belt, as you might expect: Mississippi, Arkansas, and Tennessee. And the language of the Tennessee law was this: it shall be unlawful for any teacher, supported from public funds, to teach the theory or doctrine that mankind ascended or descended from a lower order of animals, or to use a textbook that teaches the doctrine or theory that mankind ascended or descended from a lower order of animals. Now, the Scopes trial is interesting from a number of different perspectives. If you just rely on the movie or the play, Inherit the Wind, for your understanding of the Scopes trial, you're going to get a very misleading picture of things. It kind of makes Scopes out look to be this persecuted person. Actually, those who were opposed to this law, and there were many progressives at the time opposed to the law, there were many religious groups, as I've already indicated, opposed to the law. They wanted to have a show trial. They wanted to have this law challenged, so they went out looking for a plaintiff, a teacher who would be willing to go to trial, willing to be prosecuted, who would stand up and say, I've taught evolution. They actually had a hard time finding someone. In fact, Scopes himself said, I don't really recall whether I taught evolution. That's what he told the attorneys. He changed and said, well, I probably did. It was in the textbook, and I know we had some charts that kind of showed that traditional, progression from ape to man or whatever, and I think I referred to that. So he was willing to be prosecuted. But as I said, this was kind of a show trial, and it was unusual in a lot of different respects. Wasn't conducted like a normal trial, in the sense that the rules of evidence were really honored more in the breach than the observance. Just to give you one example, William Jennings Bryan, notoriously, was one of the team of prosecuting attorneys. That in itself is kind of unusual, to bring in a private attorney to be part of the prosecuting team. Moreover, at the end of the trial, and again, those of you with some familiarity with the trial will recall, William Jennings Bryan was put on the stand. Well, if there's one rule that lawyers know and courts usually enforce, is that if you're a lawyer involved in trying the case, you can't be a witness in the case, even as an expert witness. And he was called as an expert witness on the Bible. So the case was highly unusual. Scopes himself and his team made a number of different arguments. They argued, and interestingly, this is going to anticipate arguments later made in recent times by the Creationists. They argued that Scopes had academic freedom and free speech rights to teach what he wanted in class. They also argued there was an obscure provision in the Tennessee Constitution that said that Tennessee has to promote science. And again, that's so vague, the appellate court said that we don't even know what that means. And he argued that it was an establishment of religion. Lost on all those grounds before the appellate court. The trial court had found him guilty of a misdemeanor and had imposed a $100 fine. But as I say, here, he lost a trial, but on appeal, the Tennessee court overturned the verdict. And I know some of you here are great historians. Do you happen to know on what ground the Tennessee court overturned the verdict? As I've already said, the Scopes team lost the key arguments. The Tennessee court found there was no establishment of religion. He didn't have a free speech right, didn't have academic freedom. but they overturned the imposition of the fine. It's because, as I just mentioned, the judge imposed a fine of $100, and under Tennessee law, any fine over $50 had to be imposed by the jury. So, appellate courts love things like this. Why? Because it gets them out of an embarrassing situation. And frankly, Tennessee was very embarrassed by this. Many people in Tennessee, whatever their feelings about the law or evolution, just thought it made them, the whole spectacle made them look like a bunch of hicks. Maybe deservedly so. But in any event, they didn't want to go through this again. So in fact, in a departure from traditional judicial reasoning, the Tennessee Supreme Court, when it's issued its decision, basically instructed the prosecutor, don't bring this case again. First of all, by that time, Scopes had left teaching, but he still could have been brought up for having violated the law before. But, the Tennessee Supreme Court said, there's no public purpose served by a retrial. You should not retrial the case. They couldn't expressly order the prosecutor not to do it, but the prosecutor got the hint, no retrial. And in fact, in terms of trials of teachers for teaching evolution, that was it. That was the Scopes trial. There weren't any further legal battles in the 1920s and the 1930s. Well, why is that the case? Does that mean that suddenly all the schools, the public schools around the country, were teaching evolution happily with no problem? No. As I said, the legal battle between evolution and creationism is a reflection of the social and political battle, especially at the local level. And I can guarantee you it'd be the rare public school district in the South in the 20s, 30s, and even into the 40s where you'd have evolution taught, at least not without a lot of qualifications and conditions placed on it. Why? Well, the teachers had to live in those towns, right? And there was a lot of sentiment against evolution. So you didn't have to rely on the law to prevent the teaching evolution. You just had to rely on social pressure. And the fact of the matter is, until the 1950s, most widely used textbooks either brushed over evolution very quickly or didn't mention it at all or didn't talk about its application to human beings. It was really only later on, as I said, in the 50s, that we had a number of textbooks devote a significant amount of time to evolution, especially as applied to human beings. So, finally, in 1968, and that's an interesting year because what happened in 1969 that kind of shows how advanced we were in science, it was actually a big achievement for us. We landed on the moon. Yet it was not until 1968 that we actually had the Supreme Court strike down a ban on teaching evolution. So the law sometimes progresses very slowly. But in 1968, the Supreme Court finally did say that Arkansas's law, which was very similar to Tennessee's law, that prohibited the teaching of evolution, was unconstitutional. And this time the Supreme Court got the reasoning right, unlike the Tennessee Supreme Court. It's not a question of whether, well, gee, there's some, religions that are okay with evolution, so therefore it couldn't be an establishment of religion. The fact is, as Justice Ford has pointed out, the Arkansas law selects from a body of knowledge a particular segment which it prescribes for the sole reason that it's deemed to conflict with a particular religious doctrine. So it doesn't matter whether it conflicts with all religion. If, in fact, the law is there because people believe it conflicts with a particular religious doctrine, then obviously it's being used to promote that religious doctrine. And therefore, it's a violation of the Establishment Clause of the First Amendment. So, by this point in time, actually fairly recent history, unfortunately, but anyway, by this point in time, it was now clear that those opposed to evolution could no longer rely on outright bans. So what are they going to do? They're just going to strike their tents, leave the field, and say, okay, it's over, right? We're going to have to allow evolution to be taught. Of course not. This is a key issue for them. So they're going to change their strategy. And what was the first strategy they relied on? Well, as I said, after Epperson, the key goal was to mask the religious foundations of creationism so it could pass as a rival scientific theory. All right? We can't ban evolution, so we have to show somehow that creationism is a science. And they coupled that with the argument about being fair and balanced. And this is actually, you have to give credit where credit is due. This is a good tactic because there's this inherent sense, Americans are in favor of free speech. We like to have debates. Every side gets to present its point of view, and then we leave it up to the public to decide. So it seems to kind of strike a chord. Yeah, sure, why not? Right? Sure, we're going to have evolution taught in the schools, but at the same time, we should have the opposing scientific view taught in the schools. And so there are a few states that passed laws, including Louisiana, which said that we have to have balanced treatment for creation science. And the way the Louisiana law was worded was that, in fact, you can't teach evolution unless you teach creation science. You can't have one without the other because, we want the students to make up their own mind and get, an informed perspective and be able to decide between these different points of views. Well, in a 7-2 decision, the Supreme Court struck down this law, saying that it had no valid purpose. The majority said, as in Epperson, the legislature passed the act to give preference to those religious groups which have as one of their tenets the creation of humankind by a divine creator. Furthermore, the court pointed out it can't be blind to the historic and contemporaneous antagonisms between the teachings of certain religious denominations and the teaching of evolution. And there was ample evidence in the legislative history that, in fact, the purpose of this law was to support the book of Genesis as it's literally interpreted, right? To support the creation idea, that, in fact, human beings are created specially by God, and this is what we want taught to our school kids. Ample evidence in the legislative record, as I say. However, as I pointed out, unlike Epperson, which was a unanimous decision, this actually was a 7-2 decision. Anyone want to guess who the two dissenting judges were, or justices? One of them obviously was Scalia. Yes, Rehnquist was the other one. And what did Scalia argue? I mean, how could he say that this is not a violation of the Establishment Clause? Well, what he pointed to were the self-serving statements by some of the legislators who had some political savvy, not enough to avoid making statements like, we need this because we need values, and values are based on God, and, if we think that we're descended from monkeys, how can we have any moral values? There's plenty of that. But you also had legislators who said, well, there's a scientific basis for creationism. There is such a thing as creation science, and all we're trying to do here is make sure our students get exposed to all scientific theories. I mean, is there anything wrong with that? Right? So Scalia argued in his dissent that there were some legislators that stated they wanted students exposed to a scientific theory, creation science, and that the court should accept the explanation. In other words, it's not the business of the court to look beyond the stated purpose given by the legislators themselves, even though, as I said, there were also indications that many of the legislators thought, in fact, hoped they were promoting religion. And the interesting thing, if you have a time, you should look at Scalia's dissent, because he admits that creation science seemed a lot like the book of Genesis. It seemed to be kind of modeled on that. I mean, he admitted that at several points in his opinion. And he said, well, it seemed to me that also the effect of teaching creation science may be to promote a particular religious viewpoint. Nonetheless, he said that we should accept at face value the statement of some of the legislators who said it's science. This is Scalia giving a greeting to some secularists he'd passed on the street. And, so his reasoning basically is if it walks like a duck, talks like a duck, and looks like a duck, it may actually be a tiger if a state legislator sincerely believes so. By the way, this is the first time the court applied the Lemon test, the test from Lemon versus Kurtzman, which said that for a law to pass constitutional scrutiny, it must have a secular purpose. The law's primary effect cannot be to advance or inhibit religion, and a law must not foster an excessive government entanglement with religion. So, what happened after this? Well, again, the creationists aren't going to give up. They've got to regroup. And they regroup by deciding what we have to do is to drain as much religious content from creationism as possible. And they were very clear about this. I mean, there's the famous Wedge document. There are other documents that show this is not something that they tried to hide or actually weren't successful in hiding. And many of them were very, very public about it. We want to make sure that we can get this passed as a science. So no references to God, no references to Genesis, no references to any type of religious thing. We're just going to talk about science, and that's the birth of intelligent design. And then in terms of tactics, the creationist ID movement tried a variety of approaches, from encouraging teachers to supplement instruction in evolution with other viewpoints, to requiring the use of disclaimers when evolution is taught. They made the argument, as I said, they took a leaf from the defense notebook in the Scopes case. They argued that, teachers have a free speech right or right of academic freedom to teach intelligent design if they want to. No court has accepted that, by the way. If you're a public school teacher, you have to follow the policy of the public school district. That's part of the deal. Well, how about this? Can a school board promote the teaching of intelligent design by encouraging students to consult intelligent design textbooks and having students told that intelligent design is an alternative to evolution? No. And this essentially was the ruling in the Kitzmiller case, which I think most of us are familiar with. Now, Kitzmiller was a bad case from the perspective of the ID camp for a couple reasons. One was that the purpose part of the Lemon test had clearly been violated based on some rather ill-advised statements by members of the local school board who had said, before they were coached by their lawyers, yeah, we want this in here because, it fosters religious values. Shh, don't say that, right? And then later he changed their tune. Oh, no, this has nothing to do with God. God, it could be an alien, the intelligence. We're just talking about intelligent design. And the defense argued that there were no references to religion in the intelligent design policy, so could not have been designed to promote or endorse any particular religious belief. And the court in Edwards had said it is permissible to have a variety of scientific theories presented to students. So Judge Jones, the district court judge in the case, had to decide whether, in fact, intelligent design was a science. And he held that it wasn't. Intelligent design relies on supernatural causation, whether or not it contains an explicit reference to a deity. And importantly, and this is obviously one factor that distinguishes science from non-science, it makes claims that have not been and cannot be tested. He further went on to say that the intelligent design policy singles out the theory of evolution for special treatment, misrepresents its status in the scientific community, presents students with a religious alternative masquerading as a scientific theory, and directs them to consult a creationist test as though we're a scientific resource. Very firm, very strong, very well-reasoned opinion by Judge Jones, by the way, an appointee of President Bush. So you think, gee, are we finally past it? Is this the end of creationism? Because they've given their best shot, so it should be over. No. They're going to try other strategies. It's been severely wounded, but they're carrying on. The creationist camp is carrying on a guerrilla struggle. For example, they're trying to have supplemental materials adopted that point out gaps in evolutionary explanations. And where possible, and this is an interesting case, they're jumping at opportunities to argue that criticism of creationism shows a hostility to religious belief, and therefore that is a violation of the Establishment Clause. And I predict this is a strategy that's going to be followed in a number of cases. Remember, under Lemon, you can't show a preference, you can't promote religious belief, but you can't promote irreligion either. You have to be neutral. And there was a recent case, this actually went up to the Ninth Circuit. There was a teacher who allegedly made very critical remarks about creationism and about religion in general. He called creationism a superstition. And a student brought a claim that this was a violation of the Establishment Clause. Ultimately, the Ninth Circuit dismissed the case, but it dismissed it on what lawyers might call, or others might call, technical grounds. They held that the teacher had qualified immunity. Public officials have qualified immunity under circumstances where it's not clear to them whether they would be violating the law. And because this is actually a case of first impression, the court said, well, the teacher really wasn't on notice that the remarks he made may have been a violation of the Establishment Clause. So this hasn't ended the issue by any means, and I predict this is a tactic that will be used in the future. Furthermore, courts cannot exercise day-to-day control over what's taught in the classroom. Ultimately, as I emphasized at the beginning, this is a social struggle and a political struggle. It's what teachers believe themselves and the social pressures they're subjected to that are important. I'm going to show you this, this slide, which underscores this point. This is recent, by the way. This is a poll that was conducted in early 2011. A survey from the National Research Council that shows 28% of biology teachers around the country teach evolution without qualifications. In other words, they say, yeah, it applies to human beings as well, right? 13% of the biology teachers expressly advocate creationism. That's a large number if you take that out across all the biology teachers in the country. So why is that going on? Because no one's challenging it. Because they're in communities where, yeah, there may be a few people who accept evolution, but you don't want to have your kid be the sacrificial lamb going out there and, be subject to abuse. So it's going to go on. And this is probably the most interesting and maybe the most discouraging statistic. There's a lot of self-censorship going on. 60% of the biology teachers teach evolution, but they qualify it in some way. For example, by telling students, all right, this is what many scientists teach about evolution, but you don't have to accept it. Right? It's out there, it's a theory, and we're going to discuss it, but remember, it's a theory. You should talk to your parents or not, whether you accept it. Obviously, that's a very huge percentage. It's the majority of biology teachers. So again, this is a struggle that's going on. And it's symptomatic of many of the struggles. I've obviously focused on evolution and creationism, but obviously that's just one aspect of the battles that are going on between religious right and secularism. And as John pointed out, it's not, you can frame it in those terms, but there are a lot of different battles going on and a lot of different strategies being followed. I don't want to sound too pessimistic, but the interesting thing is that the fundamentalists, the religious right in this country, has never been more than a minority. It was a minority back at the time of the Scopes trial. But they're well organized, they're well funded, and they have highly motivated activists. Moreover, both at a national and a local level, they've leveraged their strength through political alliances. I mean, I don't know how many of you have, either for fun or just to make yourself depressed, look at any of the GOP debates. But it's amazing to me that only one candidate, and of course he's the one with only like 1% or 2%, John Huntsman, actually had the moral courage to say, actually I believe in science and I think evolution's okay. None of the other candidates were willing to say that. In fact, some of them come out strongly against evolution, or like Perry said, well, in Texas we teach both things. Perhaps unwittingly acknowledging that the Constitution, people in Texas are just thumbing their nose at the Constitution. That's the way we do things in Texas. Those evolutionists come down here, could get pretty ugly. And what are we doing? Well, unfortunately, I think, not everyone, but too many secularists are sitting on their hands. They don't realize how important this battle is. And again, it's not just this one battle, but as John pointed out, it's a whole series of battles. And moreover, battles that are shifting ground in terms of where the conflict is taking place. And don't want to be as scary as John, but I could hardly match that. But it is important to realize, we may think, well, we won all these legal battles, we're in the clear, evolution, it's going to be taught, it's over. No, that's not the case. This is a continuing struggle, and we can look forward to battles in this area for many years to come. Thank you.